Good afternoon and welcome to the third of our autumn webinar series. Today we're joined by Patrick Smith from RBB Economics. Patrick has done lots and lots of work in South Africa and Europe and various other jurisdictions. He's now based in Johannesburg. And Patrick, thank you for joining us this afternoon.
Thanks very much, Anthony.
Today we are also joined by my colleague Avias Ngwenya, and we are going to be talking about cartel conduct and the implications for business and management. Patrick's going to be sharing some of his insights in a number of cartel cases that he's worked on. Obviously, he can't go into detail in some of the more recent cases that he's involved in, and I know he's been testifying in a cartel case as recently as last week. But we're going to ask him to share at a more generic level some of his experiences, and in particular his views and experience in calculating cartel damages and the economics of cartel cases. Before we get into that, just a brief introduction to the topic. South Africa has experienced quite a sea change in the approach to cartel matters, because historically the approach to cartel cases by the competition authorities was purely on a civil basis. So in other words, companies that were found guilty of cartel conduct by the competition tribunal had to pay financial penalties, which were obviously quite significant, but there were no implications for the management and the individuals concerned who were responsible for the company engaging in the cartel behavior. That all has changed since 1 May 2016, and we're going to talk a little bit about that as well. There are obviously implications for companies that belong to trade associations, and lots of companies have historically been involved in trade associations, in terms of which the association often gathers information from its members. And, in some associations, they would publish statistics that they had gathered from their members, and that varied sometimes on a weekly basis, sometimes on a monthly basis. And we're going to talk to Patrick a little bit about the implications of information exchanges through trade associations, and what are the risks in doing that, and what are the benefits in doing that. So we're going to get his views on that. And then we're going to talk a little bit about follow-on damages, so cases where companies have admitted that they have engaged in cartel behavior and there's been a certification from the tribunal. What happens where third parties now want to claim damages, and how are those damages calculated? We want to touch a little bit on class actions, and as well as overcharge calculations. Now, just to set the scene and just to discuss what are the types of conduct that are likely to involve cartel behavior, if we look at slide 4 of the presentation, we've listed there some of the types of categories of conduct that are likely to be viewed as cartel behavior. Now, obviously, in South Africa, we have this bifurcated approach where certain types of behavior between competitors, the so-called Section 4(1)A offences, are not regarded as cartel behavior. So that is, certain conduct between competitors will not fall within the category of cartel conduct, and there a rule of reason approach is followed. But the Section 4(1)B offences is really the cleanest cases of cartel behavior, and those involve price fixing between competitors, market allocation, and collusive tendering. And those are really the real categories of conduct that companies have to be concerned about, because it's this type of behavior that will give rise not only to civil fines and to civil follow-on damages cases, but also now to criminal liability for directors and managers. And if we turn to slide 5, this is really dealing with the introduction of criminal liability, which came into being on the 1st of May 2016. And what this really means is that directors or persons having management authority within companies can now face criminal convictions and criminal prosecution if either they were the persons who caused the firm to engage in the cartel conduct in question, or perhaps somewhat controversially, knowingly acquiesced in the firm engaging in that behavior. Now, often a question that we get from clients and from third parties is, well, what does knowingly acquiesced mean? Now, the definition says that you had actual knowledge of the conduct in question. And because this is now a criminal offence, traditionally courts interpret these types of provisions quite restrictively. So actual knowledge, we think must mean that you would have to have, fairly clear knowledge of the cartel behavior. It wouldn't be good enough that this was rumor and innuendo round, the water cooler or the lunchroom table. This would have to be very clear-cut knowledge of the actual conduct in question. Moving on to slide 6. So how would potentially a criminal prosecution work in future? Well, there are one of two scenarios. One is that the firm concerned has admitted to the conduct pursuant to a settlement agreement with the Commission, classified as a consent order, and that once that consent order has been ratified by the tribunal, that effectively then the National Prosecution Authority could seek to prosecute any individuals who were involved in the relevant conduct. And the other scenario is where the tribunal or appeal court has made a finding or an order that the firms concerned have engaged in cartel conduct. And in either of those scenarios, theoretically a prosecution could follow, provided that the Commission has not indicated that the individuals concerned should be deserving of leniency and have made submissions to the National Prosecution Authority to that effect. And really what that would mean would be that in certain cases, either involving leniency applicants or even cases where third parties have cooperated, the Commission might say to the National Prosecution Authority, you don't need to prosecute the particular individuals concerned because in fact they've extensively cooperated with the Commission. Now the penalties for a criminal conviction are very serious. They can involve a fine not exceeding 500,000 Rand and, more importantly, imprisonment for a period not exceeding 10 years or both. And these are obviously very, very stringent penalties. There has yet to be a criminal prosecution in South Africa, and obviously there is a test case which is coming down the line. And Patrick, I don't know to what extent you have knowledge of this, but the criminal prosecutions in the UK to date haven't been particularly successful. In fact, I think most of the attempts at criminal prosecution in the UK have failed dismally, from what I could see. And I don't know if you've got any thoughts or comment on that.
Yes, I think that's right. I think it's marine hoses, isn't it, or one, which I think started Correct. In the US, which led to an extradition and pursuit. But I think criminal penalties are a challenge for policymakers. I think the clearest example of changing criminal penalties, obviously the US, the United States approach to leniency. So I think it's since about 1978 the US has allowed criminal leniency for whistleblowers, and that's from the Department of Justice. And what the US did, it was I think in 1990 or 1996, the US enacted the ACPERA, or the Antitrust Civil Penalty Enhancement and Reform Act, so 2004 actually, where the US not only maintained that criminal leniency for whistleblowers, but also enhanced the immunity from treble damages, and they took away the joint and several liability for whistleblowers, and that was associated with, people argue what the causality is, but that was associated with a big increase in the number of leniency applications and the number of cartels that were discovered and prosecuted by the US agency. So it is an important part of incentives, and destabilizing those incentives is providing some carrot to people in the form of criminal leniency as well as civil.
And you're quite correct. I think even in South Africa now, your incentives to apply for leniency in cartel cases have doubled in a sense, because not only does the company potentially get immunity from civil fines, administrative fines, but the individuals concerned will now also have a great incentive to apply, because if the Commission believes that they have cooperated, they can approach the National Prosecution Authority to suggest that they should also have immunity. So we seem to be following the US system to that extent. But it also appears that the US has been far more successful in criminal prosecutions of cartel cases and sending individuals to jail than has been the case in the UK, where these prosecutions seem to have founded significantly, and one wonders why. Are the US just much better at criminal prosecutions than the UK authorities? And is it because they've been doing it for much longer? Or do you think there's something else that's going wrong in the UK system which accounts for their high failure rate in criminal prosecutions?
I should certainly defer to any UK lawyers who are on the phone, but as I understand it, those two agencies are just set up fundamentally differently. The DOJ, as it has its antitrust division, but it can draw on a much larger pool of talented lawyers who are used to going through forensic commercial criminal investigations and really finding the necessary evidence, whereas the UK agencies have come out to an almost entirely administrative proceeding background and really don't have that same depth and strength. But it's a very complex issue. But I think the two the two agencies have just had a fundamentally different history and resource on that prosecution, the really litigation prosecution side. You also see it in even civil litigation undertaken by the UK agency.
The reason I raise that question with you is, I think some people have worried that a similar problem will arise in South Africa, yes. That our prosecution services are not sufficiently engaged with these types of very complex types of matters, and may have difficulty in prosecuting these types of cases, and therefore that our experience of criminal prosecution might be more similar to that in the UK, because our agencies are not sufficiently equipped to deal with these types of cases.
I know several people who were at the UK agency at the time, Marine Hoses and just after that, and it was a very difficult time for the agency in that respect. I'd say the two things to be concerned about from a policy perspective is, number one, as you say, the complex capabilities of the agency to bring those sort of cases. Will they be able to find the right evidence to bring before a judge, convincing evidence? The second one really is the coordination between the NPA and the competition agencies to really coordinate this question of leniency. What I should imagine as a policymaker you don't want is to completely undermine the incentives of the leniency program, which have been very effective in really flushing out a large amount of alleged cartel conduct in South Africa, and to have those affected by problems in the coordination between civil and criminal investigation and enforcement, in particular leniency.
Patrick, I now want to touch on what I think is a really crucial area in this regard, and that's this issue of characterization. As you well know, our courts have developed this concept of characterization, and I think, as I've always understood it, the purpose of characterization was to distinguish so-called hardcore cartel conduct, which we all recognize as contrary to the public interest and contrary to consumer welfare, from that which really, in a sense, is not designed to be of a hardcore cartel nature, and which is, in a sense, part and parcel of normal commercial behavior. And I'm thinking here of restraints of trade, non-compete clauses in the context of sale of businesses, joint ventures, etc. And our courts have been at some pains to suggest that type of behavior, properly characterized, should not be regarded as hardcore cartel behavior and should be treated differently. And that obviously has fundamental implications both for penalties, for criminal liability, etc. So just wanted to get your views on characterization and what are the nuances and complexities around that.
Certainly, thank you very much. It is a fascinating topic as an economist, and firstly, just one on structure and how did characterization come about in South Africa. I am an economist, so I must be careful to behave myself and stick to the economics. But I've spoken to a lot of lawyers about this, competition lawyers and counsel in South Africa primarily. And initially, there was quite a lot of pushback against this idea that there is a characterization that had to come out of the Supreme Court of Appeal and then endorsed by the Competition Appeal Court. And where does it come from? Does it belong in our laws? Surely it's quite simple. And I think as an economist, just trying to focus on the substance rather than the form or the wording of the Act and the jurisprudence, I think it really just mirrors the similar arrangements that exist all around the world. The Americans have their per se versus rule of reason approach for two different classes of conduct. And as to which falls in which class, it's really informed by this jurisprudence, in particular their cases that really have changed that approach as economics and business understanding has developed over the last century, have really informed which fall into each bucket. Similarly in Europe, we'll talk about a few European cases just now, they have the object or effect restriction. Now, interestingly, so they have if you like, a harsher bucket, an object type of offence, which is for those more hardcore type restrictions, more likely to harm competition. But even their object bucket in Europe, this is a point that's often misunderstood, but I defer to the lawyers, but many of them have told me this is correct. In Europe, even an object restriction can have an efficiency justification. There are cases like airline alliances, Tool Technic, the RPM case we worked on, admittedly that was in Australia. There are a number of airline alliance cases which were object restrictions, but were effectively, through the different legal means, excused by the European Commission on efficiency grounds. It's not impossible. But then their effects type of assessment is effectively a rule of reason type, a balancing. So on to what is characterization. I think there are very strong reasons for having a characterization part in this, or consideration in the application of Section 4B in the South African Act. I think this is really fundamental, and another counsellor I spoke to had a lovely way of putting it. He said, the terms price fixing, if you look at 41B1, those terms are laden with meaning. They're not simple dictionary words. You could go and say, well, I fixed a price. Well, I bought a water from the garage and the man fixed a price to me. That's obviously not price fixing. So these are laden with meaning, and that's interpreted by the courts. And the blanket term we use is characterization. And I think the Competition Appeal Courts put it very nicely in SAB, or similarly the Supreme Court of Appeal in ANZAC, when they say things like characterization is really about separating those types of conduct that are very likely to harm competition from other types of conduct where we really should undertake a balancing test. I certainly won't. I don't think many sensible economists would try and advocate for some carte blanche for all sorts of cartels should have some balancing effect. If you think of this as an economist, you've got to think of the efficiency of investigating as well. And if it would take huge amounts of resource to go and investigate what is obviously a cartel on day one, that might be a bad policy choice. So there's very obviously harmful conduct. Like if two competitors get into a smoky room at Frankfurt Airport and decide we're going to fix prices, jack up the price by 10%, agreed. We go out, we memo it to everyone. That's so unlikely to be efficient that we should put that in a box and say, actually, as an agency, the Competition Commission simply doesn't have the money to go and investigate that in detail. That's just prohibited. I don't want to hear your excuses. But other types of conduct, there might be some good, some bad come from them. There might be a pro-competitive rationale. I really think we should weigh up the pro-competitive, anti-competitive potential. Now, just to take one step back, what is the context for this? There are a vast number of cooperations that happen in a market economy all the time. So, if we really want to get high level, this market economy, or trying to have efficient markets that work for consumers, is a fundamental driving force that very few people, I think, appreciate the magnitude of that effect. But effectively unleashing market economies, primarily in China and India, allowed over 1 billion people to rise out of extreme poverty in the last 25 years. So these are fundamental features, and I think it is worth investigating where you have arrangements that might be pro-competitive, might be anti-competitive, but go into that balancing act. I think in the US, these are often called joint venture arrangements, where there's some kind of vertical element to an arrangement. They'll almost always take a rule of reason approach. In the European Commission, they call of these horizontal cooperation agreements. Now, not all horizontal cooperation is bad. It doesn't mean just because you're horizontal or your competitors that it's definitely a cartel. You could be engaged in research or many aspects. But other than the absolute hardcore restrictions, the Europeans would also say these are primarily effects-based assessments. You should weigh the pro and anti-competitive effects of many of these types of cooperation.
Now, Patrick, some critics would say that the problem with characterization is that it sort of opens the door for competitors to take advantage of that type of scenario, and that it's very difficult then for the Commission to make effective cases because there's always the potential for the characterization defense to be offered, and that it would be better if there wasn't characterization because it makes the regulators' job easier because the characterization defense can't be offered. What's your response to that?
I think the challenge to a view like that is really, if you look at the settlement cases the cartel cases that the Commission has either concluded or settled over the last decade, you will very clearly see some obvious cartel infringements. And in those cases, characterization simply has a very cursory role. We've characterized this properly as a cartel arrangement. It's so obviously unlikely to be pro-competitive. But what you'd say against that is, who would have anticipated 10 or 20 years ago that Uber would be so popular, or Airbnb, the sharing economy? Who would have anticipated the number of collaborations that there have been, in particular in high-tech industries, in research and development joint ventures? None of that would have been possible if we had a blanket ban that said anytime you talk to anyone at the same level as you in the supply chain, you're going straight to jail. So I think it's really this unpredictability of the economy. It can be very harmful to have a broad prohibition on types of conduct, and it really is an iceberg effect. You'll see the few things that are happening now. You won't anticipate the Ubers or the Airbnbs just never coming to existence.
Some would say that that's the role of exemptions, that if you want to have sort of beneficial arrangements between competitors, which could potentially enter the realms of price fixing or market allocation, well, you should be applying for an exemption, and that's the way to deal with it. And that's why sort of characterization doesn't have a great role to play, because you should rather be going down the exemption route. What's your take on that?
I think the South African experience that I've seen, and certainly the experience internationally on exemption, is really that exemption really struggles, or processes like exemption struggle to keep up with the pace and the complexity of the real economy. It's really practically, can you get around the almost infinite ways in which horizontal competitors do cooperate, in many instances pro-competitively? That's not to at all excuse the hardcore restrictions, the proper market allocation, price fixing. That is obviously harmful to competition and to consumers, who are obviously the primary focus of this. But if we have too broad a prohibition, we'll really prevent horizontal firms from getting into cooperation agreements that really do help competition be more effective, help South African business be more efficient, and ultimately help consumers.
Can we, just on that, because I think often there is this difficulty when people are thinking about their arrangements or agreements with people that they might construe as competitors. And obviously now with cartel behavior being criminal in South Africa, individuals in management are nervous to get into arrangements which they might construe as potentially entering into that sort of realm. Can you explain, in your view, what is the difference between a substitute and a complement? Because obviously that goes to how potentially some of these arrangements between parties in what may appear to be a competitive relationship would be, and how those should be construed.
Certainly. So I think for the business people out there, when you're thinking of a horizontal cooperation agreement, if you make it a very general sort of term, that anything you might do with someone else at the same level as you in the supply chain, I typically think of three screens you might go through. These are substantive things. I'll try and steer clear of too much of the economic jargon, but we think obviously with your lawyers on, firstly, does this involve competitors? Are they actually producing substitute products, which is the point I'll come to first from Anthony's question. And second, does it involve collusion? Is it this conduct that is consistent with collusion? And that's what, when council say these terms are laden with meaning, they mean price fixing, market allocation. Those mean collusion. It's type of cartel conduct. And thirdly, is it presumptively likely to restrict competition? So firstly, to the business people, think in your minds, what is the ultimate rationale of this? What is the outcome of this cooperation going to be? Is it going to be more innovation, products coming to market that couldn't otherwise come to market, more efficient distribution, more effective competition with rivals, or is it going to be simply raising prices, reducing outputs? When we talk of substitutes and complements, I've got a picture here just of the two shoes and 2 bottles of milk. This is the fundamental distinction to economists of where you at least starting to look at problems. On the left-hand side, you see 2 bottles of milk. If you increase the price of 1 bottle of milk, people buy the other competing bottle of milk. Those are substitutes. And generally, if 2 producers of substitutes, things that compete closely, where consumers are choosing between them, if they were to get into a smoky room and make some arrangement would typically harm competition if they were both to say, well, let's fix prices another 10% higher, if they were to mutually agree on a price level. But conversely, if you have complements like a left and right shoe, imagine hypothetically, of course, that there's a left shoe factory and a right shoe factory. What happens if the left shoe factory wants to raise prices? He sells less left shoes. He also hurts the right shoe factory man. So these are complements. I mean, if they got together, they'd actually say, no, stop raising prices of left shoes. You're hurting me in my right shoe factory. Let's agree on a sensible level of price for both shoes. Otherwise, people just aren't going to buy any shoes. These are complements. They should be priced together. And we often find this in the sports rights, media rights. You often find complementary capabilities, which it does make efficient sense for these to be sold together. So if you think of these two football teams, so I have to localize myself, soccer teams, the Orlando Pirates or Kaizer Chiefs, sure, they're massive competitors on the field, but if you have a Soweto derby, it's not very much fun with one of these teams and not the other. They're selling a combined entertainment experience, and it makes sense that some types of media rights like this are sold together. These are ultimately complementary inputs to a single experience.
Airline alliances are always a very interesting topic, Patrick. And, often airlines will say, well, in order to offer consumers a seamless service around the world, you need to have these types of alliances. How does that fit into the category of potential cartel behavior?
So this is this is one where you really have to look at this balancing, and nothing in the characterization debate, I don't think, is to say necessarily types of conduct where we think there should be a balancing are all definitely pro-competitive. They should be hailed as making South Africa great again. But I think it is worth doing a balancing in these cases. So in the airline alliance, for example, imagine I had my hub in Tambo, Johannesburg, and someone else had their hub in Singapore. There's probably much more efficient ways that we could offer consumers, both in Singapore and in Johannesburg, for example, a much larger set of connections without having to duplicate those two hubs ourselves. Now that's a potential efficiency rationale. Of course, on Johannesburg to Singapore, there may be concerns of some cooperation on that particular route. You might offer more frequency, better quality aircraft, your load factors might be affected. There might be a whole host of things, but there's at least a balancing that you can see here. It might be more efficient that these two hubs cooperate to offer consumers potentially some benefits from those pro-competitive effects. And you need to weigh those against potential anti-competitive effects, which I think is pretty much the way these things are looked at in most jurisdictions in the world.
Now, I for my sins, did quite a lot of these airline alliances at one point. And, we had to go through quite a rigorous process of applying for exemptions. Yes. In a lot of these cases that I did. And, that went on for several months. And, it had to go through the formal process of being advertised in the government gazette and third parties giving comment and then a long evaluation process from the Commission before the exemptions were granted. And I suppose that goes to your point, which is that if your only option in these types of cooperation type arrangements is to apply for exemptions, it's potentially destructive of efficiency enhancing type of initiatives of this kind, because you kind of have to put them on hold while you go through the exemption process. Now, the Commission might arguably say, well, that's the formal process we want, and we don't want you making a discretionary judgment about whether this falls on the right side or the wrong side of cartel conduct. What's your view on that?
It's quite an interesting one. So I suppose there's a question behind this, which is what level of integration do you need in order to achieve these efficiencies? So you often find some joint ventures are very integrated. I mean, they're almost like a full merger. Now there you'd have to go through merger control, which by its nature is presumed innocent until found guilty. I mean, these are rule of reason approaches. You don't go to a merger and just presume, well, if the tribunal doesn't make a mistake, that's a prohibition. You go there and you're weighing up the evidence, anti-competitive, pro-competitive. No one's going to jail yet. And that's for a full integration. You might have joint ventures that fall a little bit south of that, so the two parties remain some independence, but they are creating a joint venture, perhaps upstream, to do some production or research and development. And if the assets that are contributed, you might fall over a threshold that you actually need to notify that, and that would take some time. I think quite an interesting perspective on this is, if you go back to the late 1980s, you can remember Mr. Reagan was president, and there was a lot of liberalization in the UK, US economic policy spheres. And there's quite a lot of discussion about, forming these joint ventures. There was actually, I think there were 3 bills before the Senate at one point saying, let's liberalize and almost presumptively bless all production joint ventures, all cooperation agreements, because, and it's an odd reflection, sort of 30 years on, that there was a theory at the time that America was becoming less competitive because of the rise of Japan, not China, as Mr. Trump hypothesizes now, but Japan. And the idea was, let's bless all these production joint ventures without even so much as a look. And then we'll make America great again in the late 1980s. And there's some great papers by Carl Shapiro, who's since been the chief economist of the Department of Justice twice. And he wrote a paper with Bobby Willig looking at, should we liberalize even further our approach to production joint ventures? And they say, no. We already apply as a matter of course, this is even back in 1990, we apply as a matter of course a rule of reason to these sorts of joint ventures. Now, to Anthony's point, there's a great quote from that Shapiro and Willig paper, which is it rational that we have a per se approach to joint ventures that happen by agreement as opposed to by merger? Is it rational to be even harsher on a looser arrangement, which is simply an agreement with some potential pro-competitive efficiencies, than it is on a full merger? And he says obviously no. So I think, the answer to your question, there are a range of different levels of integration you might need to achieve these efficiencies. Some of them will require merger notification. If they fall south of that and purely are a matter of agreement, I think it is sensible that there is a characterization route by which to assess those. And one more comment is, the European Commission has been through this, where you had to notify all agreements. And that was, well, let's not be too direct on an open line, but it didn't work very efficiently. People waited many, many years for responses. And then, of course, in 2004, the European Commission had its modernization agenda, when it said, actually, no, go and assess yourselves. And to me, that's effectively what characterization is we have an approach. We have a 41B1 box for bad price fixing, but there is a characterization element to our South African law which says, go and assess yourselves. If this is genuinely efficiency enhancing, there is a balancing mechanism. When you come to the tribunal or to the Competition Appeal Court, we will hear you out on that. And if there's a genuine rationale to balance pro and anti-competitive effects, we'll hear you out and we'll say this should be in another box, not in the criminal cartel box.
I suppose part of the difficulty in an emerging economy like South Africa is, on the one hand, you want to be incentivizing efficiency initiatives and you want business to be growing and developing, and you want cooperation arrangements that will stimulate economic activity in the country. On the other hand, you want to stop cartel behavior, which is inherently destructive of a competitive process. And I guess it's striking the right balance between that, and that's probably what the courts have been trying to do in developing the characterization defense, for want of a better word, or the characterization approach to whether conduct falls within cartel behavior. But I think, just last thought on that, it does require some quite careful and astute legal advice, because obviously if you get that wrong, you could end up in a pure cartel type of world, which these days, has severe criminal ramifications apart from heavy civil risk associated with it. So, getting the right advice about which side of the fence you fall on is quite important.
I think that's exactly right. I think if you look at the statistics of the Commission's caseload, we look back, 10, 15 years ago, when I started testifying on South African cases, there's a huge focus on mergers, and many other much more experienced folk have written and spoken about this, and I think that was right, building institutional memory. I think 2 years ago I saw the caseload had moved to 85 cartels in litigation, and now it's about over 120 or so. So I think there's a massive focus, and there's single-digit numbers of mergers and other cases that the Commission will pursue. So I do think the Commission has been very aggressive on its characterization of cartels. I should say I'm not sympathetic. I mean, it would be the wrong term. I'm supportive of the Commission's work against cartels. But frankly, if you look at the weekly press releases and you look at what are settled as cartels, there's a lot of conduct out there which, as you say, as a developing country, it's important to go and stamp on. And there are a lot of bona fide cartels where this debate is not necessary. However, I think over-regulating and putting too high a burden on business is bound to be counterproductive. I mean, places that have gone that route, too centrally planned an economy, Cuba, North Korea, that's not so much fun to live as a poor person. So I think that there's no feasible way that an agency with resource constraints can anticipate the full complexity of potentially pro-competitive cooperation agreements that are necessary in an efficient functioning economy. So certainly the hardcore cartels need pursuing, but I think there's a very strong, I suppose I'm making a case for characterization. But to your question, it's exactly, factually it is the case that there's a very active prosecution of a wide class of conduct, which I think doesn't only include hardcore cartels. It is a matter for very, very detailed, sophisticated legal advice.
Now, Patrick, you've prepared a very interesting slide which deals with multiple essential patents, which I confess only an economist could have put together, given the complexity of the slide. Do you want to just clarify what the slide is explaining?
Yes, for sure. I was just thinking again of these substitutes and complements, and if you think of how your smartphone's probably in everyone's pocket or on their desks now, works. This is a diagram of it's roughly, imagine that it's standard essential patents, so patents that are essential for your mobile phone to work. And these are the different people that hold some part of the technology that works in your phone every millisecond as it's humming away, doing its hundreds of different apps. And this is just showing you the complexity of all the different entities. Now, you might say, well, they're not cooperating if they're suing each other, but you need some form of cooperation to actually get all of that technology into a phone. So this is just a pictographic of when you get into high-tech industries, there are so many ideas and so many cooperations of people ostensibly at a similar level of the supply chain that had to cooperate to make this smartphone revolution really happen. And that, I think, is just, for me, summarizes how difficult it will be for an agency to say, okay, anything at the same level of the supply chain, go straight to jail. This is the sort of complexity that you simply couldn't anticipate.
Now, there have been a couple of cases, both in Europe and in South Africa, where the courts have dealt with the, trying to separate out the hardcore cartels from the ones that shouldn't be regarded as that, and really should be characterized as things which are more pro-competitive. Patrick, do you want to talk a little bit about some of the EU precedent on this?
Sure. I think two cases which always, top of my mind when I think about this topic, and one's a little bit old, 2005 or so, but the second one, Carpanquer, is a bit newer, and they're really interesting because they've either been referred, a question from the Spanish courts up to the European Court of Justice, now they're called the Court of Justice, or they've been appealed. And they really highlight this point of what we would say is characterization in the European parlance is, were these agreements necessarily likely to harm competition? They said, did they have as their object the restriction prevention of competition? And I'll talk through two of them just in a minute each and just hopefully really illustrate some of these ideas. So ASNEF Equifax was really a case involving credit insurance, but let me speak in parallels as though imagine this were car insurance just so we can relate to it better. And imagine all the car insurers kept a central record. They exchanged information amongst one another on who had crashed their car and who was a good insurance risk and a bad insurance risk. As I say, the real case is over in credit insurance, but imagine it in cars. And the Court of Justice had to see, well, was that sharing of information necessarily harmful? Now, if you think about it, it's detailed information. It's on an individual level. It's shared amongst competitors. It sounds, pretty hardcore. But actually, if you think about it in economic terms, what's the overall rationale of this conduct? And it was to avoid what economists call asymmetric information, which means me as an insurer, I don't know if Anthony's a safe or a reckless driver. And if I had this central information repository, I could go back into the last 10 years, right back into student days, and find how many good and bad incidents have there been. And the safe Anthony's, I can get a better premium. The unsafe Anthony's, I will give a worse premium, but economically that's much more efficient. And typically, as you know, it's lady drivers who should benefit from the lower premiums and men the worse. It's separating the driving Miss Daisies from the greased lightning drivers. So this is fundamentally efficient. Yes, some people are worse off. Yes, it's exchange of detailed customer-specific information, but there's an overall efficient economic rationale. Now, the second case, carte bancaire, potentially sounds even worse if you put it in. So there's an association of French banks, and in banking there's issuing activity. So I will send you cards, and that's relatively cheap as a bank. You just put the card in the mail. And then there's acquiring activity, and that's installing ATMs and making sure you don't have a cash and transit heist on the way to refilling those ATMs and then maintaining them, etc. And this is, loosely speaking, this is an agreement amongst an association of banks saying we've got an interchange fee, much like mobile termination fees. There's an interchange fee between banks, and guess what? The small banks will pay more. Or specifically, the banks that invest less in the acquiring equipment, the ATMs, will pay more when their users come with their very cheap debit card and go and put it in the hole in the wall and get their money. Us big banks will pay less because we've actually invested in that. And again, this is an agreement amongst competitors. It's talking about an interchange fee, which is relevant to consumers. And moreover, it makes the small guys worse off. Doesn't this sound terribly hardcore? And actually, no, if you think of this in economic terms, there's a free rider effect here. If you didn't have arrangements like this, I'd just sit back in my internet mansion and issue cards all the way and never invest in any acquiring equipment, the ATMs or the tellers, or where you can actually use this, and nothing would ever get done. So this, again, went to the Court of Justice, and in broad terms, this didn't have as its object the restriction of competition. It was trying to address an economic inefficiency. That's this free rider effect. So again, I hope these two aspects, you've got to my mind, or my simple conceptualization, you've got a big economic problem you were trying to solve. It wasn't a cartel. You weren't just trying to jack up prices or reduce output. You've got a big economic problem you wanted to solve. In the insurance markets, you want to solve asymmetric information, not knowing enough about your customers. And in the bank card issuing, you want to make sure there's incentives so people go and put the ATMs in the holes in the wall and make the market actually work.
Those are two fascinating cases, and I think we've also had two interesting cases in South Africa which follow similar lines. So the SAB case and the Dawn case. The Dawn is the more recent case, in fact decided very recently by the Competition Appeal Court, and a case we were involved in, and that related to a non-compete provision in the shareholders agreement, and the question was, did that amount to a form of market division? And the Commission argued fairly strenuously that it was indicative of a market division arrangement, but ultimately the court said that from the time that the agreement was concluded and the shares were purchased, that the parties then ceased to be potential competitors of one another. And I think a lot of commercial business would run into difficulty if these types of non-competes or restraints were viewed as market division arrangements, because they're often a fairly standard feature of commercial behavior. And this is probably why characterization is quite important in this context. The SAB case, from memory, involved a whole bunch of distribution arrangements between SAB and its distributors, some of whom were obviously independent companies. And the question again was, well, if they had exclusive distribution territories, did that also constitute a form of market division or market allocation? And again, the Competition Appeal Court said, those weren't a form of market allocation arrangements, and properly characterized were more of a vertical type of arrangement between a supplier and a distributor. So I guess these are two, good examples of the types of cases, Patrick, that you were referring to, where really, there are inherent efficiencies in these types of contractual arrangements, and that's why the appeal court in both cases found that they weren't systematic of, market division type of arrangements. And obviously, from a commercial point of view, I think a lot of commercial behavior would be very restricted if you couldn't have these types of non-compete arrangements or these types of distribution agreements.
I think that's exactly right. I think, I was asked actually, what's the biggest, what's a really important lesson of the last decade or so of South African competition policy practice? And I think it's really keeping in mind these longer-term investments. We can't say that businesses invested so much in what economists would call a sunk cost. They've invested, they can't get it back, and therefore we can just go and change their business model. You've got to worry about what's happening next time, and the extent and the complexity of the economy is such that you don't want, as an agency, it would be very inefficient to prohibit these broad types of agreement. They say you've got to not just think about, there might be slightly more competition if we do away with this non-compete in a sale and purchase agreement. You've got to think, actually, there might not be any more sale and any more efficient use of that asset. That competitor wouldn't even exist without the necessary restraints. There's one caveat, of course, to this. There's a limiting point, and it's in all the guidance and all of the papers on this topic, is if the JV is just a veil for what's actually a naked cartel, then fine, the same conclusion applies. I mean, that is just a cartel. But if there's an integral part, which is really an efficient rationale for this conduct, then you really should have this balancing test. It's not to say, 4.1a exists, a part of the Act which says, actually, let's look at these horizontal agreements and see, are they more pro-competitive, more anti-competitive? It's not to say you'll always come out and say anything in that balancing box is always good for the economy, but there are just so many types of examples of situations where it's worth doing that balancing. Otherwise, you're going to do big harm to the economy.
And I suppose, part of the difficulty, as you've said, is trying to separate out as a business whether your agreements or your arrangements fall within the rule of reason type of approach, the 4.1a types of prohibitions, or are you in danger of your agreement being characterized as a type of naked cartel, as the Commission did in both the SAB and the Dawn cases, because then you're in a totally different world of potential criminal sanctions, massive civil fines, etc. And I guess it's working out which of those two boxes you fit in, and that's really where the legal advice becomes quite imperative, because otherwise you might inadvertently end up in the wrong place.
Yes, I think that's critical, particularly given the agency's stance to these issues. As I say, the net has, to my mind, been potentially over-inclusive. It might well be this is a learning period for the agencies, but if you look at the cases, there are many cases that are very clearly within cartel conduct, and then there are a significant number of cases where, frankly, there really, I think, should be a balancing test applied.
I want to talk a little bit now about trade associations and information exchange. Because historically, certainly in South Africa, lots of businesses belong to trade associations. It was quite common in a lot of trade associations for a time for members to submit information to a central repository, and for that repository to publish aggregated data, and then sometimes more detailed disaggregated data. And some would argue that again was efficiency enhancing, because it gave competitors insights into trends in the industry, etc., and that they could adapt their behavior and become more competitive as a consequence of that. But I think that there are competing schools of thought. Some will say that greater transparency of information facilitates more enhanced and vigorous competition. Others will say, but that's a route to coordinated behavior, whether it's pricing or otherwise. Avias, I'm going to ask you to give us your take on this from an economic point of view. What's your thoughts about information exchange in the context of an industry association, and do you think that should be viewed more or less benignly by the competition authorities?
Thanks, Anthony. I think, first of all, one really needs to get a sense of the fact that information exchange in a South African context is not per se prohibited. So there isn't an outright prohibition against information sharing amongst competitors, within whatever constitutes an industry trade association or some other industry body that's been established for, most of the times what we see is, very rational commercial reasons. And the difficulty that, we often find with clients within industry or trade associations is they often don't necessarily understand what information should they be sharing, what information can they share, what information is problematic, at what degree of disaggregation, and in many respects the information they're sharing is benign and doesn't result in any anti-competitive outcomes. And what you'll often find is there are a lot of rational reasons why firms will share information. I mean, you can look at the mining sector, where they share information on the number of accidents, on safety measures which have been put in place, the number of deaths, etc., which obviously is geared at ensuring that at an industry level you've got greater safety and security, etc. And you can look at other sectors that we've worked in, an automotive sector where government has a particular stance on improving or increasing the number of black industrialists which are involved in that sector, and you've got large automotive companies that are submitting information to the Department of Trade and Industry for that purpose. And in that respect, you often see that type of information sharing isn't necessarily problematic. Now, the difficulty comes where firms start sharing information which is what we would deem commercially sensitive information. So it's information which, other than through this trade association, you wouldn't be sharing with your competitors. This is information around pricing. What price points are you pricing your goods at? Think about information about sales volumes or regions where you're potentially looking to enter, or capital cost and the cost of capital expansion. I mean, when that type of information starts getting shared amongst competitors in a trade association, what you often see is the competition authorities start really raising their heads and saying, look, this we believe is potentially problematic. And one of the things that people need to think about, or that competition authorities rather do think about, is the degree to which information exchange can be used as a means of coordinating a cartel outcome. So it's not to say that information exchange in and of itself could be seen as anti-competitive, but information exchange could be seen as a means of ensuring that you have what's essentially a stable cartel. So sharing information about sales volumes could be seen as a way of monitoring cartel outcomes where you've got some sort of market allocation. And I think that was the case in the concrete and cement cartel in the early 2000s, where they divided markets and territories by geographic regions and essentially were monitoring volume sales within those different regions. So in that case, information exchange is problematic, but really it's about understanding the nature of that information, the purpose that it's being shared for, and the degree to which there's a level of granularity associated with the information that's being shared. I think in the slide that Patrick's prepared, you see the first two bullets. One talks to the anti-competitive effects, facilitating and sustaining coordination, and the second one, really talks to some of the pro-competitive benefits of sharing information. So increased transparency for customers, or reduced uncertainty, diffusion of technical knowledge, and really allowing efficient coordination. And this goes back to the point that Patrick had made earlier about coordination and sharing of information can lead to some really pro-competitive and efficient market outcomes, which are beneficial to consumers and beneficial to the economy in general, the economy at large. And the big question that we really need to think about is, to what degree, if we're thinking about information exchange, to what degree are the competition regulators engaged in a form of sort of overcompensated enforcement against information exchange? Because that's really the challenge. It's trying to distinguish where that line exists between pro-competitive sharing of information and anti-competitive sharing of information. Yeah.
And Patrick, is there a distinction between reducing competitive uncertainty and reducing market uncertainty, and where's that line to be drawn?
Yeah, this is a really interesting one, and it is a difficult line sometimes to work out. But I think Susan Athey was the Clark medalist in about 2007. She's a fantastically clever economist. She actually was the chief economist at Microsoft for a time, has been to Harvard, Stanford, etc. Anyway, an incredibly clever lady. She did a number of papers on collusion in tenders. So where there's a bidding, an auction type of arrangement, and how can you tell whether or not there has or hasn't been a cartel? Anyway, to any geek economists out there on the line, she's done some amazing work on actually reducing the amount of information you need to try and work out if people are in a cartel or not when you're in a tender situation, which would have been kind of nice at the Treasury over the last 10 years. But anyway, moving back on. She has this great way of explaining this, which is, if firms know more about, so what stops someone from bidding aggressively in a tender is they might actually get it wrong. They might misvalue they might have the wrong value of this asset. And what are they going to do? They're going to underbid if they're buying something, or they're going to overbid if they're selling. So they're going to be risk averse, as humans usually are, corporations certainly are, and they're going to hold back. If they knew more about the market, they're going to bid closer and closer to the proper competitive price of exactly what they think it is. They're going to discount by less. Now that's pro-competitive. So if firms could find out more about the market, like in my insurance example, if they find more about their individual clients and how risky a driver they've been in the last 10 years, they can get closer and closer to what's an efficient competitive price for them. Now, obviously in the other direction, the separate class is competitive uncertainty. If I'm just worried about what Anthony's going to do in this bidding competition, and I'm uncertain, it's actually, if I don't know anything about his bid, I'm going to bid right down to my competitive best offer, because that's where I'm most likely to beat him. But if I do know, if he and I have been in a smoky room beforehand, that's when I soften my bid. So these two effects do work in different directions. So anyway, that's a bit of the theoretical framework, but hopefully makes sense. If industry associations exist to allow firms to know more about the market, to have less risk in how the market is, it'll probably enhance their competitiveness, allow them to do benchmarking, standardization, learning best practices, etc. If it's just there to allow them to know more about what their competitors are doing around the table, that's when the anti-competitive comes in. And often, I'd almost go back to the previous slides. I know we're now into information exchange, as Avias has said, that's under 4.1a. It's a rule of reason type approach. But almost have the same approach as you do in characterization. What's the ultimate purpose of the information you're exchanging? And I've been in client meetings when they say, I don't know, we inherited this, it's been going for 20 years, who cares? We just, we start fires with the price list that comes out anyway. But genuinely, think of the information you're getting in. Is it necessary? What's the purpose? Is it so you can do benchmarking, so you can incentivize your employees to go and beat that market share target, etc.? Or is there some other purpose? And really examine it on that basis.
And is the sort of level of aggregation of information or the level of disaggregation, whether it's forward-looking, historical, are those types of criteria important?
I think that they are, and the tricky answer is it often depends on the overall context. I mean, I mentioned some examples just now, like ASNEF Equifax, where you've got incredibly disaggregated information that is exchanged amongst competitors and can still be pro-competitive. But generally, when you're talking about pricing information, when you're talking about customer-specific deals, like the deal that I offer customer X or customer Y, the price I give them, the amount of volume that I've allocated to them, then more disaggregated is often riskier. Because if I say to Anthony, well, there are 3 people in this room, and these 2 I'm giving so much volume, he knows pretty much how much is going to Avias, and he can use that in his bargaining with Avias, thinking what sort of price he should set. And if I've got that amount of disaggregation, particularly forward-looking information, I'm going to set in these provinces and these regions to these customers these sort of price in future. You know exactly what to anticipate and exactly what you don't have to undercut. So generally, this more disaggregated, forward-looking, very frequently exchanged information. If I tell you information with a year's lag, it's not really going to help you in a fast-paced industry. But if I tell you today what my price is going to be tomorrow, that is really going to help you. And again, the very accurate, very disaggregated information is particular information that's looking forward was going to be typically more risky. The final bullet on this side is slide 18 here. Let's look at the public or private nature of the information. As you said, some of the efficiencies are around the public getting access to this data. Price lists might reduce uncertainty or search costs for customers. If it's private, more alarm bells should be ringing, but that doesn't mean it's necessarily anti-competitive. As I say, the insurance examples or the banking examples, you can have private information that's efficient to exchange. But again, go back to that fundamental question. Think, why are we exchanging this information? What is the pro-competitive rationale? What's the rationale that's going to get consumers, we're going to make us as business people more efficient, going to get consumers a better deal? And if it's not there, those are the loudest alarm bells.
And Patrick, in these types of cases, is the fact that there's a sort of basis for coordination important? In other words, do there have to be credible punishment mechanisms? Are those a sort of sine qua non for these types of cases? Does there have to be a focal point for coordination? are these necessary elements in these types of cases?
So I think for a coherent theory of harm, they are. I mean, they're certainly not. They're not strictly required for the Commission to write you a number of letters and really ask for a settlement, but they are required for a coherent theory of harm. We were talking all about coordination here, softening of competition. So economists would always say, if you're competing, what is softening of competition? What is coordination? The soft competition we're talking about. It's about firms deciding, well, I should be pricing, say my costs are 100, I should be pricing down at 100 or 101. And actually, I'm going to take my foot off the brake and price at 110 or 120 because I've got so much information on Anthony's business, I don't have to try that hard anymore. It's that softening. So if you're not, if you are competing absolutely as hard as you can, you're probably in a different context, and that can really, as part of a proper legal assessment, that can really give you some comfort that yes, we're exchanging all this information, but we're in a wildly competitive industry, and it's to make us more efficient. And look at where we are, look at the margins that we're pushing to try and expand this particular market.
Now, Patrick, in the next slide, you've got a rather intriguing picture of a fish with the question: is coordination always bad?
Yeah, this is an interesting one. It's a case study. It's a quarterly journal of economics for all the econ geeks out there. And it's a nice one. It's Rob Jensen. So there's several Jensens who write economics papers. This is one of them. And it's interesting. So this is Kerala, a state in southern India, and it's a fascinating state. I don't know if any development economics wonks out there, but it's a great state to talk about economic development. It's one that Amartya Sen and others have written about extensively. It really puts forward or prioritize, let's say, human development indicators, not just GDP. But anyway, that's a small aside. There was a great economic experiment around 1996, 1997 with the introduction of mobile phones to essentially poor artisanal fishermen on this South Indian coast of Kerala. And they went out and caught pelagic fish like an anchovy here, is, I suppose, the closest analog, or sardine. And they went and caught them, and fish being what they are, they're all in one place, and you find lots of fishermen go there. And the cost of fuel being what it is, they would go to the nearest village on the coast, and they'd sell their catch of the day. And hey presto, you'd find 3 or 4 fishing boats arrive, all full, and they would have too much for the local market, and not being able to refrigerate their catch, they'd waste quite a lot of that. So you'd have a lot of wastage of fish. In some villages, there'd be too few boats, prices would be very high. In other villages, prices would be very low, but there'd actually just be way too much supply, so that fish would be wasted. And what Jensen does is he looks at the introduction of mobile phones, which worked at least for SMSs up to sort of 20, 25 Ks offshore. And you could find, and he then looks at pricing and supply and how this has worked. And actually what he found was the fishermen started chatting to each other when they'd finished their fishing for the day, and they did in fact coordinate on which villages to go and supply. And although this might sound like a cartel, it led to much more efficient outcomes. So avoiding situations of oversupply and wastage of fish, avoiding extreme shortages and very high prices for fish in undersupplied villages led to a significant increase in consumer welfare. So just to say, these information exchanges, by the way, they're 20. It wasn't necessarily talking about prices, that we're 25 Ks offshore. From this vantage point, at least we can get to different villages. But if we wait until we get to harbour, it'll be too late. Let's try and divide up this in an efficient way. That actually was efficient. So some of this information exchange, where are the other fish? Where's the bulk of the catch today? It's an interesting article, just that could be efficient in some contexts.
I now want to move on, because we're running out of time, to talk briefly about class actions and the economics of class actions in particular, and then also to talk a little bit about follow-on damages cases. Starting with the class actions, this is obviously in its infancy in South Africa. We've had 1 or 2 cases in this kind. We were interestingly involved in the first class action damages case in South Africa, and the Supreme Court went about setting out the criteria for these types of cases, and has indicated that you have to have prior certification of the class generally as a requirement before you institute proceedings. And they've set out the relevant criteria that you have to meet, which includes the existence of an objectively identifiable class, a cause of action which raises a triable issue, and common issues of fact or law in relation to the class. But I guess the more interesting aspect of all of this, besides the legal criteria which need to be fulfilled, is the economics of these types of actions. And Patrick, can you sort of just give us a headline sense of what you think are the key economic considerations in these class actions?
Yes, I think this is fascinating, and it was a great pleasure to work with you and your team on this bread class action. We worked on a couple of the class actions starting in the UK and had exposure to the procedure in the US a number of times. And this is a fascinating procedure. I think it often looks very pro-poor or pro-access to justice, and it feels like a great thing. I think the real balance here is, or let me tell you, when you find out about the contingent claims funding industry, you might think slightly less sort of Robin Hood, but it's an interesting approach. And I think the two economic fundamentals is, number one, it is an aggregation of claims. So if you have claims that are only worth R1 each, no one's going to bring those because the costs will be far too great. But if you could gather together several million of those claims, you'd see silicosis, see bread, see aspects like this, it might be worth bringing. But that aggregation has got to be balanced by something. Now, I think the Supreme Court of Appeal and the Constitutional Court, in particular the SCA, set out a great list of factors, and they had a really good balance. What does aggregation do in economic terms? It cuts the costs and it increases the number of claims. There are more cases that will be brought if you could aggregate and bring them. But I think you need some balance. Otherwise, any case that might hypothetically be aggregatable will just be brought, and that might not be fair in itself. You might find people inventing claims and just aggregating them and saying, look, I've got a huge number, please settle, otherwise we'll go to court. And by the way, we've got 65 million South Africans behind us. And I think that is balanced by requiring some evidence of this valid cause of action at certification. So it's a prima facie test, it's not a full test, but I think it is necessary to have that. I think also, and this is going from like a Daniel Kahneman view, he wrote this book, Thinking Fast and Slow, the Nobel Prize winner in economics from 2001 or 2002. He had a great number of thought experiments about aggregation also increases risk. It increases variance that and risk in a legal judicial sense is risk that you make the wrong decision. And I think that again, the risk that someone comes with a completely fictitious claim and says, well, just settle and I'll give you a 50% discount. When you aggregate all these claims together, you should again have that prima facie test before you even get, as part of certification, before you even certify. And what else does aggregation do? It assumes all these cases are the same, which I think is a further economic justification for certification, really testing commonality, which I know is one of, if not the most important element in certification cases in the US. Are these cases all the same? Because if they're not, and I have to individually find out what was the causation and harm to each individual bread consumer in the Western Cape, this isn't going to be the great, efficient Shangri-La that I was promised when class actions were invented. I talk a bit about extrapolation. I think so. Aggregation, this can increase risk, and I think that motivates for a bit of evidence of a valid cause of action or some prima facie case. It's also a representational device. It effectively, in an opt-out class, it takes away people's rights, sometimes without them even knowing it, which is even more reason to require some certification and commonality, because you might be taking away people's rights who are much more harmed than average, and they might prefer to make their own class. I think that again motivates for some certification, some testing, a prima facie testing of, is it a good case? Is it a case in which everyone's likely to be similarly harmed?
Can we talk a little bit about the economic assumptions underpinning some of these cases? Because, often that is where these cases go wrong. And I'd be interested in your views on that.
Yes, I think the key thing when thinking about economics is not a set of immutable laws. Economists often think, well, when prices go up, demand goes down. Actually, for some products, it's not that case. So what does economics bring us? I don't think it brings us presumptions where we can predict the future. Of course, as an economist, I'm a fantastic predictor, like everyone else was, of the dot-com boom and other booms economists have been poor at predicting. So I think what economics brings us rather is a toolkit. In particular, we've got qualitative tools to try and put together a set of market facts, and this can even be at a certification stage. These are qualitative facts. We can put them together in a model and think, what would you expect from this? Is this evidence broadly consistent with this prima facie case, with this cause of action? Secondly, there's some quantitative tools which you can use, not sparingly, you can use at certification stage and see, is the evidence sufficient that these are substantially a common class? So it's more, think of it as a toolkit that you can apply rather than an immutable series of laws. Well, there was a cartel, therefore everyone in the country was almost certainly harmed the same way, and they should all be in the same class.
Patrick, I then want to end off with follow-on damages cases, because these are becoming increasingly frequent in South Africa, and I think lots of companies are now realizing that when there's a consent agreement which is made in order by the tribunal, or there's a finding by the tribunal that there's been cartel conduct, that third-party customers now have the ability to bring civil cases for damages. But what's not always well understood is both the law and the economics around this. So while, once there's been a certificate issued by the tribunal that there's been a finding of cartel conduct, while it's not necessary in the subsequent civil case to then prove the merits of the claim, it is necessary to prove the subsequent amount of the damages. Now, we've seen some quite successful ones recently, the Comair case against South African Airways, where significant damages were awarded. The Nationwide case against South African Airways was another reasonably successful case. But other cases haven't been quite as successful, and I think people don't readily appreciate the onus of what they have to prove in these types of cases. And they also sometimes don't understand the principle of the pass-through principle. So do you want to just give a sort of bird's eye view about the economics of these follow-on damages cases and the types of issues that one has to be alive to?
Certainly, this is a fascinating issue, and it's one in which the business context is really critical. I can think of probably 24 follow-on damages cases I've been involved in, where you go in, you see the business people, and you find not only one, you'll find 3 or 4 specific facts of that industry that really drives how damages might or might not be transferred from a prohibited practice like a cartel. So I think of it in 5 steps very quickly. If you had a prohibited practice, imagine 2 producers got in a smoky room, they agreed prices are going to go up. Number 1 was the implementation. As I say, think back of economics as a toolkit. You can test that. When was the price list change? How often was it adopted? Look at before and after. Look at a number of other approaches. Was it implemented? Secondly, what was the counterfactual, economics speak, but what would have happened if there weren't that agreement? Have you got cost margins from before? Can you see what likely would have happened? And you'll see in this graph that's up on the screen, what is that counterfactual? Prices still would have moved around potentially for cost movements or competitive responses. That really comes us to the third point, is what would competitors have done in response? They might have cut price, they might have shifted, you might have lost some volumes if you'd raised prices, but what are those competitive responses? The fourth point really is pass-through. So imagine that you raise the price of wheat by 10 to a customer, then goes and make bread. The price of bread may be raised. So what is the damage that baker has received? Well, yes, they received a higher price. They passed on some of that to indirect purchasers. And I think at the downstream level, if you imagine that baker then competes with someone else, what would the responses have been amongst his competitive set? So other bakers could have stolen some of his business. They could have cut their own prices or responded, or could have well, you'd normally expect them to respond by raising prices, but they might have increased their volumes. So I think there are at least 5 steps you can break this down. And a quick point on this graph, I think, is in particular for pass-through, where someone who's claiming damages from you has been able to recoup that. There are varying legal standards and presumptions around the world, but if those indirect purchasers, so the end consumers, can come and claim damage, I think economically it's only sensible that there's got to be some sort of reconciliation between those 2 cases. Effectively, that you don't have double jeopardy, that you shouldn't have to pay that damage twice. Now, it's a legal question that differs jurisdiction by jurisdiction. Should the indirect purchaser claim from the direct purchaser, or claim from the ultimate producer who is involved in that infringement? But I hope that's a clear explanation of what the general principle is.
Yeah, so in essence, really what you're saying, Patrick, is it's important to establish if there has been a so-called overcharge, whether the person who the overcharge was made to actually pass that on to his own customers in turn, because if that is the case, then he may not have suffered any damages.
He may have suffered none or even a much smaller damage, and actually the person who should be claiming should be the indirect purchaser. As I say, the legal presumptions differ around the world and who can and can't claim. But that's a question, yeah.
And do these types of cases, in a sense, involve sort of predictive models? Because, I guess it's quite difficult to predict, what competitors' responses would have been under particular factual scenarios. And how does one go about evaluating that?
So I think the key thing here is to be reasonably robust. So economists have probably 4 or 5 different commonly used tools to try and work out what is the likely effect here. You look at what happened before the conduct, what happened after. You have a couple of predictive models. You really try and test this against the available data and see if you've got a reasonable estimate here. Is it robust to your tweaking of various assumptions? And that's what really gives you confidence. And ultimately, when you testify, it gives the judge confidence in your assessment.
I think just to end off, the long and the short of this is not straightforward. I mean, these cases are complex. They require difficult analysis, and they're not always readily provable without that type of detailed analysis.
I think that's exactly right. You've really got to do your homework. I think part of our job, the fun part of our job is trying to make these understandable, make them intuitive to the decision maker, and whether you're written or oral. But I think the key part is you've got to do a lot of homework to make sure this is robust. That's right.
Patrick Smith, on that note, thank you for joining us. It's been a pleasure. And that was a very insightful and helpful discussion. Thank you.
Indeed.
Thanks, Avias. Thank you, Anthony. Thanks very much.
Good afternoon, and thank you.